Are you thinking about switching jobs, but your employer-sponsored green card application is still pending? Well, here are some things to keep in mind. Hello and welcome to The Immigrant Lawyer. My name is Leah and I'm a California-based attorney by day, yoga Pilates instructor by night, and millennial mom at all other times. If you're thinking about switching jobs or employers and have a pending I-485 adjustment of status application, then you may be eligible for what's called AOS Portability. AOS Portability has three main requirements. First is that you are the beneficiary of a pending or ultimately approved employment-based I-140 petition. Now, your I-140 petition is in the EB1, EB2, or EB3 preference category, but if your I-140 is in the EB1A, exceptional ability, or EB2, national interest waiver preference categories, then you don't need to go through the AOS portability process, since these two preference categories in particular don't require a job offer. Second, your I-485 adjustment of status application has been pending for 180 days or 6 months or more when uscis, U.S. Citizenship and Immigration Services, receives your application to port. You can determine how many days your I-485 has been pending and whether it has been pending for the required 180 days for AOS portability on your I-485 receipt notice. The receive date is the receipt date or when USCIS received your I-485 application. The third main requirement for AOS portability is that the job you're switching to is in the same or similar occupational classification. Now, this includes jobs with the same employer, but perhaps a different location, or with a totally different employer, but in the same occupational classification. So these include lateral movements, career progression, or for example, you are currently an individual contributor, say in an engineering position, and you move within your same company to a different company into a more managerial position, then you may be eligible for AOS portability. And these are some other factors to determine whether your jobs are same or similar. So once you determine that you meet all the requirements for AOS portability, then your new employer can submit your AOS portability request. This involves filing the I-485J, confirmation of a bona fide job offer or request for portability with USCIS, along with a copy of your I-485 receipt notice and the I-140 either receipt or approval notice on which that I-485 is based, as well as a detailed description in non-technical terms as best as possible of how the two jobs are the same or similar. There are a few other things to keep in mind when thinking about AOS portability, but before we get into those, feel free to subscribe to the channel for more videos like this one. So for AOS portability, fortunately, you will get to keep your earliest priority date, so you won't have to worry about restarting the clock in that sense. However, inner filing or the transfer of underlying bases does reset the 180-day clock required for AOS portability. So if your current employer recently did an inner filing for you, which is switching from preference categories. So for example, your I-485 was under the EB3 preference category and you switched over to the EB2, then doing that does reset the 180-day clock required for AOS portability. So if that's your case, then you will need to wait until your I-485 has been pending again for the required 180 days. You can submit your I-485J AOS portability request to the designated USCIS filing address, but you could also submit it during your adjustment of status interview or in response to an RFE, a request for evidence. Thanks for tuning into this video about AOS Portability. Feel free to give us a thumbs up, leave a comment below with any questions, or feel free to share your experience with AOS Portability. Again, my name is Leah. This is the Immigrant Lawyer. See you next time.